Speaker, and President of the Senate, Joe Negron, was in Pensacola today, and they have different ideas on how they want that money spent. So we're monitoring that very closely with the legislators, and we're going to be working with your staff to see what's the best way, how we can get some of the money to move this thing forward so we can create an amenity. And it's going to benefit the users of US 98, as you know. But more importantly, it's going to benefit the users of the city of Destin. The residents will use this facility. So with that, I'll open it up for questions. I just wanted to end with the impacts and the costs.
Sorry, discussion? Mr. Destin?
Mr. Atkins, I'm a new member of the council. I haven't got to meet you before. I appreciate all the work you're doing.
It's Helms, actually, Atkins, who I work for.
Fair enough.
No problem.
Sorry about that. Mr. Helms, what is your level of involvement with the connectors to 98 of the Crosstown connector? I've seen, I think we're going to attach over at Stallman to 98, and then the other.
Oh, you mean the other connections?
Yes. There's two connectors that will attach to 98, and then of course we'll have the Crosstown.
Our focus and our scope is between making that final connection between Azalea and Legion to make that connection in there. I know there's a bigger picture. Y'all wanted us to focus in getting this. You'd been working on it so long. You wanted us to get that connection out. Now I can do. No. Well, I've thought about it, but we've driven it many a time, and
sure.
we've had a timeshare here in Destin for 30 years.
So I'll direct this to any member of the council or to Greg. Then, to what extent have we explored the impact of finishing this Crosstown connector, specifically on the Stallman intersection? Because as it stands right at this moment, in the summertime, it's a completely dysfunctional intersection. We've shifted most of the harbor most of the harbor visitors to the northern side of the road, and they're consistently hitting the button to try to get across. We haven't really explored any walkovers, or what I'm saying is, many of you have seen it. The traffic will spill down past the cemetery, and then it'll spill over onto Cybert. Then it spills over, and I've seen it at Dewey's where it's so bad with people trying to take a ride on 98, trying to get away from that intersection, that they've spilled over onto Calhoun, and you can't even get into Dewey's, and it goes almost down, sometimes pretty close to where we're going to put the new park.
Yeah, let me address the issue. The FDOT has committed as part of the 3R project to study the intersection at Stallman and Highway 98. And you're correct, it is basically not functioning very well during the 100 days of summer. So that was a request back in, I think, September, October of the City Council as part of the pedestrian study they performed. We asked them to look at that intersection. We also asked them to look at installation of the 5 pedestrian crossings, lighted pedestrian crossings, which they've committed to do by sometime, hopefully by Memorial Day. It may spill over into June. But DOT did commit as part of the 3R project, and I believe it's now pushed out, David, correct me, into 19, the 3R. So they did commit to look at that intersection as part of that.
Ms. Ramswell?
Thank you, Mayor. Thank you for coming tonight, Mr. Helms. This is one of those positive things that we were talking about earlier, looking forward, having completed, and all the good things that come along with it. So thank you.
Mr. Marler?
Thank you, Mayor. I have to agree with Parker on a couple of things here because, I call him Parker. It's hard to say Mr. Destin when I sit next to his father for so long. The one thing I've noticed on Stallman, too, that he's talking about and backs up is Stallman will be actually backed up all the way to Azalea, and Mountain Drive will be backed up, too, and nobody going to give a quarter. It gives a quarter to let anybody else in, and most of that has to do with the fact that most of that traffic backing up is turning right, leaving Destin, going into Fort Walton. And so, I don't know when and I think Parker has come up with the right idea. Once if we do 4-laning to Azalea, we're still going to be bottlenecked at a 2-lane at Cybert, at Stallman. So that's one of the things we're going to have to figure out. And down on Calhoun where we have Cybert because it angles this way. And so I think that's one thing we're going to have to address. The other thing I needed to address was how have we, what inroads have we made in the purchasing of the properties that we need to? I understand the last meeting you were here, we talked about that, and that some of the people have already been contacted. They're on board because whatever reason they see, cha-ching, the dollar sign. And I'm wondering what the average is going to be, about how much we're going to end up spending on land requirement.
And I'll let staff address some of the right-of-way.
Yeah, I think is up there you have the estimate of the 2.7 total dollars necessary to acquire the right-of-way is anywhere from 2.7 to 3.4 million dollars. You are impacting 16 residential properties. Several of those property owners are homesteaded property owners. Several of those folks would like to have discussions about acquisition of their parcels. Some of them are seniors who've been in their homes for a while, ready to do something a little different. So hopefully as part of this discussion, you give us some consensus. We've got to make sure that whatever properties we purchase, we do it consistent with the appropriate state and federal guidelines relating to relocation and appraisals and so forth. And if this is, if you give us the green light, we will start working with those affected property owners. I had one of the ladies came in last week that she had found a piece of single-family home she would like to relocate to in Destin. She wants to remain in Destin. Another lady would like to move out by her daughter in the Walton County area. So to me, if we can acquire those, especially the homesteaded properties, folks who would like to move, then we'd be better off doing that versus condemning their property. But several of these parcels are most likely going to have to be acquired through the use of eminent domain because they're not going to be willing to sell. But of those 16 residential properties, you have two significant multifamily townhouses that have to be acquired. So that's some of the policy direction that we'd like to get out of you tonight as relates to, are you agreeable for us to go ahead and start, pursuant to the state and federal guidelines, the acquisition of those parcels?
Eminent domain is always a dirty word, but I can see where we're coming on that. And now, is this price, I don't know if you care who answers this, based upon current markets or what we think the market's going to fluctuate back and forth?
You'd have to do the appropriate appraisals at the time and get the value, and hopefully you can come to terms with the property owner. And then there will also have to be a relocation package consistent with those state and federal guidelines.
Okay.
Yeah, we had a gentleman in Chipley that works for me that's done it for years, done the estimates for DOT, and he followed the protocols and doing the conceptual stage relocation plan and the cost for that. Now there's, that means they add some lawyer fees and different things to it, but it's a realistic price when you go through a formal federal or state process. And that's important because once you violate a federal process in doing that, then you're not eligible for those funds. And what we've been directed is make sure that we stay eligible for any funds available through the TPO process. And so that's why we want to make sure we follow. And it is no problem, no different than what the city of Pensacola has been doing on their airport commerce park. They've been buying property over 10 years, and they don't want to condemn property or do eminent domain, so they've gone through a process, and they've actually waited out some of the property owners, and they're down from 70 parcels down to about 15 or 16. So hang in there. It's a process.
Mr. Foreman?
I have nothing, they explained to my satisfaction.
No further questions, discussion?
Thank you.
Thank you very much for coming.
Thank you, Chip. Thank you.
Do we have something we're supposed to either consent with, or how's this supposed to? I'm trying to find it on my thing here.
I think that was just a report.
Okay, all right.
Mr. Justin Pittman?
Before we go on there, are y'all okay with us moving forward with trying to acquire properties from folks who voluntarily want to have acquisition?
Require a motion.
I would like that to be a motion.
I'll make a motion to move forward with acquiring the properties. Voluntary owners on the Crosstown Connector.
I'll second.
We have a motion and a second to to require the staff to continue their attempts in acquiring the right-of-way for this project. Any further any discussion? All those in favor, please vote yes. It's unanimous. Mr. Pittman?
Hi, my name is Dr. Julian Pittman. I live at 154 Lola Circle, and I just want to bring to your attention a couple of issues that have been happening since January of this year. One of those has to do with a lack of consistency of code enforcement within Lola Circle and also some of the surrounding neighborhoods. It's been rather arbitrary and reactionary, in my opinion. Secondly, some of the parking issues within the neighborhood itself. The design of the neighborhood necessitates that basically our driveways only accommodate one vehicle because of the offset of these sidewalks. So that if we park 2 cars in our driveway, we're violating a state law blocking the sidewalk. So we cannot enjoy full use of our own driveway. So that's brought a number of issues within the neighborhood, created some problems with one neighbor in particular, but many of us have 2 or more vehicles, and there's simply nowhere to park and sort of avoid some of those issues. The inconsistency is if you drive anywhere within Beach Drive and some of the surrounding neighborhoods, I provided some photographs of even law enforcement officers violating this code. They're clearly blocking the sidewalk. Boats blocking the sidewalk throughout this area. So again, there's complete lack of consistency within the Harbor District, which I understand and respect this law, but I ask of you to find some resolution to this so that we're not continuously getting code violations, but also able to enjoy parking in this area. As you can see from the photographs, the first page is Lola Circle, but this is again off of Beach Drive where we have parking and yards. If you keep scrolling down, again, evidence of blocking sidewalks in an adjacent neighborhood. Keep scrolling down, and a law enforcement officer blocking the sidewalk with his boat as well as another vehicle. So I have respect for law enforcement, a great degree of respect, but again, it is true. It is wanton. Yeah. It's not Okaloosa, but still, the law is the law, right? And it's actually state law, so if there could be some peace or resolution of this matter, I would deeply appreciate it.
You're not suggesting that we allow vehicles to block the sidewalks, are you?
The enforcement of this is arbitrary in nature, right? I respect the state law, but there's also something called discretion. So that's up to you.
Okay. Mr. Marler?
Thank you, Mayor. 4 years ago, when I first took office this last time, and before I purchased the house I'm in, I was renting 146 Lola, and I sympathize with you. Unfortunately, part of the problem is the way they crafted that subdivision and the way the right-of-way. Some of the right-of-way actually is wide enough that you can park on, because at the time I had a company vehicle and 2 personal vehicles, and I had to park one of them on the right-of-way. Code enforcement is the only way that you can, as far as blocking the sidewalks, and that's a very tough decision in that neighborhood as well as some of the other neighborhoods, simply because you have a 20-foot setback from the property for your house, and cars are usually at least 15, 16 feet long, and it's always going to happen until you change the way the sidewalks are done. What I suggest is that you get with the city manager and try to get with code enforcement, see what they can do for you, and then if that's not the help, then I really don't know what else we can do. From my perspective, there may be something that some of the other council members think, but I know your plight in Lola Circle, but I You know, it's just the way that things are crafted in there, but it is, if you walk at night, it's kind of cool, actually. You can actually bump into people's cars unless you actually walk on the road. But, again, like I said, I don't really know anything other than code enforcement that will help you.
Can I just make a point? I've also noticed there seems to be no consistency with regard to the setback of sidewalks. Going from neighborhood to neighborhood, I've actually walked out the distance. And why is there no consistency in that? Can anyone answer that?
That's just how,
usually the property thing.
that's just how the subdivisions were originally laid out. Usually there's consistencies in the width of the sidewalk, but not necessarily the setbacks of, to the right of way. But, from a code enforcement does make routine sweeps of neighborhoods. They, attempt to give as many warnings to try to get compliance on the parking. If they can't get compliance, then they do eventually ticket. Is the last resort. Some of these pictures deal with boats and stuff, which is part of the issue that we're dealing with, the outdoor storage that you approved in December, and we're starting to bring some of those properties through to the special magistrate. So, but they do routinely make sweeps through the neighborhoods and issue the warnings, try to get compliance voluntarily. If they can't, they will issue tickets, but that really kind of the issue of the last resort. The biggest issue we have is forcing somebody in a wheelchair or that has access into the street, and that's where it becomes an accessibility issue. So that is direction that we've given to code enforcement, is for them not to block the sidewalk and for somebody who is in a wheelchair that would have to go out into the street because they wouldn't be able to, get around the vehicle.
Mr. Marner? Oh, sorry. Mr. Ansel?
Thank you, Mayor. Are you being ticketed if you park in the right-of-way?
I received 2 initial warnings, and then I got 2 tickets, and actually had to go to court, and that was dismissed by the judge. So,
Is there any truth? I've heard that neighborhood actually was not billed to city code. Have you heard that?
that's what I was told.
It's, city manager, can you shed any light on that? Or
I don't know
perhaps
when,
engineer?
I don't know when Lola Circle was originally developed. I mean, if it was developed, huh? Yeah, I would think it would be, built to the codes that were in place at the time it was approved. If it was prior to 1984, it may have not have been, pursuant to our code, but anything after 1984 would have been.
What, sorry, did you have something to add?
There's actually a vacant lot in front of Lola, which I'm sure you're all aware of, that's kind of unpleasant looking. But in that case, they actually developed additional parking spaces. If you've ever ridden around that quote-unquote circle, if there was something similar to that could be done in Lola. There's actually a no parking space in a green area on both sides of our circle. If that could be opened up for additional parking, or why there was no parking within that area.
Is Loa under an HOA?
No.
I noticed in reviewing the minutes from the Town Center Community Redevelopment Agency meeting back on February 17th, one of the committee members, I believe it was committee member Todd, had mentioned that the church has given permission for their lot to be used as overflow. Is that something that's common knowledge? Is that new?
It's not common knowledge. There are individuals that do that. Me personally, I sometimes have to go to work very early or I return late, and even as a male, I don't feel comfortable having to walk that far to my car because of various individuals in society. So,
I'd like to see if we can explore some sort of remedy. I mean, it's affecting obviously this entire circle, and it's nothing that's their fault. It looks like in that one photo, how far back is that sidewalk? I mean, it looks a good 10, 12, 15
right.
feet.
The offset is ridiculous.
I mean, it barely looks like the truck. I mean, even a truck parked in the driveway looked like it was extending over the sidewalk.
Yeah,
I mean, I don't
there's
see
places
how.
where a full-size truck takes up almost the entire driveway, so.
What would be our options in terms of trying to come up with some way to work with this neighborhood and give them some options?
Can I address the issue? Do each one of these homes have garages?
They do, yes.
Okay, so typically, and I haven't looked at the code for this time period, but I wouldn't imagine it's changed. Single-family residents have a setback requirement, and we still do in our code. The setbacks are typically 20 feet to maybe sometimes a little longer. And the parking requirements are 2 vehicles per single-family home. So each one of those homes, if they have a garage and their driveway is 20 feet from the house to the sidewalk, then there's your 2 parking spaces. So it would meet code. But what people do, unfortunately, they use their garage for storage. So that automatically eliminates a parking space. And so the folks stack essentially into the right-of-way. And that's where you have this exact situation. So as far as code enforcement is concerned, I would doubt that that we could do anything to alter the fact that you do have 2 parking spaces and that the cars are parking in the right-of-way across the sidewalk. As far as roadside parking is concerned, you know, that's always something you can look at, and there's a provision in the code for that.
You've got the exact same issues in Twin Lakes. You've got the exact same issues off of Misty Way. Unfortunately, folks do use their garage, which was originally calculated as part of the required parking as storage, and then subsequently now you got 2 vehicles or sometimes 3 vehicles. So, I mean, I'm not saying there's not options, but there would be very, very expensive options, you know, to retrofit these subdivisions that are been built over the last 15 to 20 years to make them compliant or accessible for, you know, the number of vehicles that a lot of households have.
In Mr. Pittman's defense, and nothing against what you said, Mr. Campbell, when I lived at 146 Lola, the area for the washer and the dryer and the water heater were in the garage. I tried to put my wife's Ford Focus, which is a very small car. It wouldn't go in the garage. There is no way a car can actually go in there if you want the laundry facilities. We tried many a time.
Yeah, it's definitely designed for compact cars, which not everyone has, and there's several families in there, and
yeah, Ms. Ramswell's car would probably fit there, but that's about the only one that would fit.
right, and then the difficulty, once you get the car in there, to actually open the door as well, so you have to get out of the car. So there's that.
Mr. Dixon?
No, I was going to ask about the homeowners association and Mr. Destin.
Mr. Foreman?
Yeah, my question was answered.
Mr. Braden?
Thank you, Mayor. I definitely feel your pain on this one, and I wish I knew the answer to it. Did you say you were getting ticketed for parking in the right-of-way?
So I'm where the red car is.
Right.
I have a vehicle that's parked in that same proximity, so half my vehicle is blocking the sidewalk if I park in that manner. So, for example, that red car got a ticket.
Right. But if you park in the right-of-way,
Right.
parallel with the sidewalk,
Right. I would not get a ticket in that case.
Okay.
But I have 3 vehicles.
Right.
4 actually have a trailer as well, so.
Is it possible for the homeowners, if they wanted to re-pour that sidewalk next to the road? So that it's not 15 feet up into their yard? Is that possible?
I mean, it's possible you could relocate the sidewalk if you did that by the whole subdivision. But I think you're seeing some folks that actually park in there right now, so now they're not going to be able to park on there because that's where the sidewalk's going to be.
Right. But if it did help, I mean, if they could, if they, not this guy, but I mean, this gentleman's case, if he had two smaller cars and that, if the sidewalk was out by the road, he could get his cars in there. I mean, is that something that's doable or no? Or do we have to go back to the subdivision? Of course, he doesn't have a homeowners there,
Yeah,
but
it would have to be, either they would all have to come together in agreement, or you'd have to do some type of special assessment project to do it. But again, this is not uncommon, especially in some of these subdivisions that were built, like Twin Lakes has almost the exact same types of issues, where the vehicles are not able to get in. Yep.
So if the entire neighborhood, or is it?
that's all I have, Mayor. Thank you.
I'm sorry. Oh my gosh, I'm so sorry. So is it a 2/3 vote of the neighborhood or the affected area? Is that the requirement if they were to try to come together and offer some sort of suggestion?
If you did a special assessment, I believe that at least, where's Steve at? At least 10% of the affected property owners, Steve. Is special assessment. How many of the other charter requires 10% to petition us, and then the 50% have to support the special assessment?
50% have to basically sign a petition to the council to support.
So we would be glad to give Mr. Pittman a petition that if he can get 50% of the property owners, not the tenants, but the property owners' support, then y'all could consider a special assessment to relocate the sidewalk.
Dr. Pittman, do you think that's something that might be helpful and could work out?
Would it also be possible, where you can see the no parking sign there? Again, that's a lot of green space, some of that city land, I assume, to offer parking in that area? Or are you aware of the history of why there is no parking within that area?
It's a drainage swell, but I would assume that the sign was posted there for probably a site triangle issue of some sort. And or if it's in part of drainage, if you compact the swells don't work, and then you have stormwater issues. But, I mean, we'd be glad to get you a petition. If the affected property owners would support it, then, city council could do it. We just did something very similar, not, relocating a sidewalk, but a roadway for Regions Way.
Mr. Destin?
Yeah, I don't see a whole lot of good answers here, other than, and I echo Mr. Casella's sentiments. I can't really offer any public money to fix a problem that, we're going to set a precedent. If we spend the money to move your sidewalks, we've got tons of these issues all over. If you can get the residents to give us a petition, then I'd be willing to explore all sorts of alternatives and ways we can figure out to alleviate this problem, but I wouldn't support that the public funds be used to just single-handedly go in and fix it.
Mr. Dixon?
I was just going to ask if we could have code enforcement just ease up there for just a little bit.
I can interject now. You cannot go there.
Okay, well, I'll say publicly, let's have code enforcement ease up a little bit, so until we get it handled. I went there.
You went there. You opened a can of worms. Let's not. Thank you.
All right, thank you.
Project reports. Councilman Braden.
Thank you, Mayor. I was wanting to, if I can, make a motion to, once a temporary city manager is in place, to allow Mr. Casello leave at a time he sees fit, and not spend out the 60 days, or he can stay the 60 days.
We have a motion to allow Mr. Casello to start his retirement once we have someone in place at his option.
It's an unagended item, so Mr. Bagby and it's going to require 5
Yeah, so it's
supermajority.
going to require supermajority to do so.
I'll second, and
Okay, we
I
have
think
a-
that's pursuant to Greg's wishes.
Okay, we have a motion and a second. First, that's a 2/3 vote, right? And
I have a question about this. Is this, he is serving out his notice, and is this going to be in any way considered a termination of his agreement?
as I understood the motion, it would not be a termination of anything. He would be paid in full for the full 60 days.
Okay, that's what I want
He-
to make sure. Okay, all right.
Once somebody's in place and feels comfortable, he can,
Okay, as long as he's going to be paid what he is, yeah.
okay. Is that, who made the motion? I'm sorry.
I agree.
That, okay. Any further comment? I'm
Yes,
sorry.
Yes, Mayor, I did.
Go, Mr. Barber.
Are we talking an interim, or are we talking permanent? Because what we just passed a little while ago was to find somebody to bridge the gap until we went and found a new person. Is that bridging the gap? That means basically he's not going to be that person's not going to be completely more informed than the next manager that comes along. That's what I'm asking, I guess, is the interim or the
I
permanent?
believe the motion was for the interim. Once the interim was on board,
That is correct.
he would
Okay,
have the
as long as-
option of.
all right.
Okay. Any further discussion? I'm sorry, I hit the voting button already, so I can't tell if you hit your lights. Okay, I'll call for the vote then. We have 6 yeses, Mr. Foreman voting no, to allow Mr. Casella to depart once we have an interim person in place and they both feel comfortable doing so.
I want to clarify, that does not require me to sign any release.
No, that was not part of the motion.
Okay.
Mr. Braden, any more?
I'm sorry, Mayor, that's all I have. Thank you.
Okay. Ms. Ranswell?
Thank you, Mayor. I had the opportunity this week, as I think probably a lot of us did, to attend the Wyland unveiling of the flag over at Legendary. And even though it was wet and rainy and soggy, it was pretty amazing, and it was wonderful to be a part of that experience. I haven't heard yet whether it actually qualified for the Guinness Book of World Records. I know they were doing all the measurements and making the submissions, but that's going to be quite an amazing accomplishment and really put Destin even greater on the map, so to speak, if that does come through. Oh, that's all I have. Thanks.
Item A?
Oh, that's right. Thank you for reminding me. At one of the past council meetings, we had done our appointments, and after the fact, I was made aware of the fact that for the Okaloosa County League of Cities, the mayor should serve as the primary, and then Mayor Pro Tem is the alternate. So I wanted to make a motion tonight to amend that appointment to reflect having the mayor as the primary appointee and Mayor Pro Tem as the alternate appointee.
I'll second that motion.
We have a motion and a second. Discussion? I see no discussion. All those in favor, voting yes. It's unanimous. Yes vote.
And that's all I have. Thanks.
Councilmember Dixon.
Yes, I'd like to appoint Mr. Corey Ledbetter to the local planning agency.
We have a motion. Do we have a second?
I'll second it, Mayor.
We have a motion, second. Any discussion? All those in favor, please vote yes. It's a unanimous yes vote. Mr. Dixon, anything else?
No, thank you, sir.
Mr. Foreman?
Yes, says I appoint of the Destin City Council representative to Tourist Development Council. I'm already on there. I was appointed actually by the county two months ago, and I've already been through the orientation, so I wouldn't want to change that.
I'll make a motion to reaffirm Mr. Foreman.
We don't need a motion.
Do we?
We've actually voted to keep him on it
Yeah, that's right, we did.
unless he chose not to.
I agree with that.
You really don't want to know at this time of night why I wrote an email.
You're right.
An email from a
You're
ship in
right.
the Panama
You're
Canal.
right.
Okay, that's
You're
right.
right. I don't want to know. All right.
Second that motion if it needs to come in the form of a motion.
No, it doesn't. We're good.
Okay, we're good. All right.
Anything else, Mr. Foreman?
No, thank you, sir.
Mr. Marler?
Thank you, Mayor. I have a couple of appointments tonight. Item A, let's see, item A, under myself, I'd like to nominate Mr. Tom Case to the Harbor CRA Advisory Board.
We have a nomination to nominate Mr. Case. Second?
Second.
We have a nomination second. Those agreeing, voting yes. We have a unanimous yes vote.
Okay, my second appointment, item B, is nomination of Mrs. Connie Trulos as to the Environmental Parks and Recreation Committee Tree Board.
Second.
Motion second. All those in favor? Oh, I'm sorry, discussion? Well, we're already into it. All those in favor? Vote yes. It's unanimous yes vote.
And item C for me will be nomination of Justin Woodard for the Town Center CRA Advisory Committee.
We have a motion, we have a second. Any discussion? All those in favor, please vote yes. Did I mess it up?
No, I think it's come. It's not wanting to play with that button there. Parker and I were having, there we go, now me. I made the nomination. All right, come on, bud. There.
It's unanimous yes vote.
And-
Anything else, Mr. Marler?
No, sir, I will refrain from anything else tonight.
Mr. Destin?
Thank you, Mayor. I'd like to nominate Miss Sandy Trammell to the Harbor CRA Advisory Committee.
I'll second that.
We have a motion, we have a second. Any discussion? All those in favor, please vote yes. It's a unanimous yes vote.
So I think we've had enough acrimony for one evening, so I'm not actually I'm gonna speak for a few minutes, but I won't be asking anybody to second motions or vote tonight. So, but what I'd like to touch on is, I've been here for about a month and a half, and what I detected at the last meeting is that this council's having a lot of heartburn over the fact that, if you remember, the Bay Estates were designated to a future land use as low-density residential in our new comp plan. I think we're just scratching the surface of some of the first issues we have with our new comp plan. It seems our future land use designations were not terribly sharply vetted by this council. And I just spent the last month just about giving myself a stroke attempting to digest our new comp plan. So I'll cut to the chase. If this council actually intends to meaningfully manage the intensity and density of growth and development, especially in the Harbor District, and as evidenced tonight in our residential areas, this document is not it. And the document unfortunately reads like we let the foxes design the hen house, in my opinion. This comp plan is masquerading around as meaningful oversight of development. It's smoke and mirrors. It's Swiss cheese from the amount of loopholes. Some of the loopholes are big enough to drive a truck through, honestly. And what's ultimately the most damning is that this comp plan completely removes this elected council from development review. I'll say that again, in case you didn't hear me. We're out of the game. We're done. Staff is going to end up handling everything. And so, you know, like I said, I've been here for a month and a half, and I've had way too many of our staff and advisors tell me that they're getting us out of the project review business with this comp plan. Literally their words. And I'll ask my fellow council members, have you ever had a member of the public come up to you and say, hey, you know what? I wish that the city of Destin, my elected council, did less of reviewing development in the city of Destin? Hadn't happened. You never got that from the city of public, or from the city's public. So one of the things that it's literally the one thing that we do just short of making sure that the garbage gets collected. And without going into theatrics, on many of the summer day, I guarantee you there's some folks that would pick reviewing development over having their garbage picked up. So the question is, where did we get this idea that we want to be out of the document, or out of the development review business? You know, where on earth did that policy motivation come from? And I think you can look at the language enshrined in our new comp plan right now and figure it out pretty easily. And just to touch on a couple of them, in policy 1131, the compatibility of a proposed development with its neighbor's activity has been eliminated as a general policy consideration. Compatibility with your neighbors? Gone. That's been struck. How many of you guys know that? I don't think very many. I don't know when the public asked for that. In policy 1217, the comp plan attempts to lay out how to calculate density intensity. You heard about that loophole I was talking about that you could drive a truck through? This is it. In developments that are mixed residential and commercial, like the Emerald Grand, or high-density residential developments, number of units won't be constrained by maximum density, but rather the floor-to-area ratio. That's a superb way to cram a ton of small units into a development without regard for the cars, the infrastructure burden, and cramming each unit representing more family units and cars. Even worse, after that, the following sentence says that the harbor zone intensity and density shall, not may, and that's a little trick from law school legislative drafting 101. If you want to bind the hands of somebody that you're regulating, you change the word from may to shall. That's in there. So you shall. The intensity and density shall not be applied to the same acreage. Look, guys, we can say that the intensity and density is not connected to a development parcel on paper, but here, in reality, you cannot uncouple the two. But for some reason, we've got it in our comp plan that you can create a formula where you can do those things. That's really troubling. And I think the coup de grace is the final sentence that enshrines a developer's right to separate a portion of their property to calculate density and different portions for the property for intensity, as if they're separate. Why? Now, what it is it's a great way to abuse the way that your formula is calculated in order to get to a point where you never have to worry about the caps that we've put into place. It's how you cram another 10 pounds of meat into a 5-pound casing that's already bursting at its seams. That's enshrined in our comp plan right now. I don't know how many of you guys saw that. So, if I've lost anybody, oh, I left one more out. In policy 1334, subsection 2, we've mandated ourselves to enter into public-private partnerships to build 2 to 3 parking garages on the north side of the harbor. Look, developments on the harbor that are already short hundreds of their own parking spaces, they're going to benefit from guaranteeing that the city pick up part of the tab for its future parking requirements. That's in our comp plan. When did the public ever tell us that's something they wanted? So ultimately, these are just a couple of the loopholes. And my primary concern is not even the loopholes, it's the fact that we are out of the review process. There's no more public benefit analysis, and ultimately, under the old system, that was practically the last vestigial part of our review that could stop development when we felt that the public didn't want it. That's gone. Everything goes to staff now. There's a word in the law, it's called perfunctory. That means it's automatic. It just happens. It goes to staff and staff gets to make those decisions. We've seen the problems where if it's just staff only, I don't want to go back there. We got to fix this. So I know Mr. Braden and Mr. Dixon both expressed concerns over the comp plan on the March 7th meeting, what exactly it contained. They promised the public to reconsider it, even at the next meeting. So I think I've sounded the alarm, guys. There's even parts I don't absolutely hate, but for all intents and purposes, my opinion, and this is theatrics, this thing's a dumpster fire. This is bad. We owe the public to go back and reconsider this comp plan, and we're gonna have to go ourselves, item by item, comma by comma, and figure out why is that in there? Well, how is the public gonna benefit from this language being contained in this document? Because I'm afraid we had a little bit too of a passive position in the comp plan as it was adopted before. So I think I'll stop there. What I'm going to do is instruct the staff to place a motion for reconsideration of the Comp Plan 2020 on the next meeting's agenda. That'll give everybody some time to read. That'll give all parties involved some time to think about some of the language that they like. They can try to defend it if they want. That's important. But otherwise, I don't have anything else to say.
Is this a time-sensitive issue?
Well, here's the thing. I'm going to have to ask legal counsel, you know, if this is a time-sensitive issue, I think where Ms. Ramswell's going with this is now that perhaps the development community that really pushed hard for this comp plan amendment knows that the jig is up and we may be reconsidering it, there may be just an absolute Wild West rush to get your permits and your DOs in. And I did hear at the March 7th meeting that that wouldn't be a problem. My gut says it is a problem. So I'll direct that I can't answer that question. I direct it to legal counsel, because if somebody comes in this process wanting a permit, wanting a development order, which comp plan are we going to put into effect for them?
I'll appropriately defer to Ms. Shirley.
Mayor, I have a question before that goes to Mr. Shirley. I had no light on.
Go ahead.
Mr. Destin, do you, just a little background, we did have Tier 3 that was come before council, and one of the problems we understood was you have 7 members of council plus the mayor who think what they think is a public benefit, then you have the developer who thinks what he's a public benefit, and the public thinking what a public benefit is. And always, traditionally, Tier 2 and Tier 1 was always staff, because it was nothing, it was everything from a residential home to less than 10 stories or more. Are you saying that you want to go back to the beginning and have council approve just about everything? Because we're going to be here every night.
No, absolutely not. I'm not suggesting that we go back to compatibility. I mean, my father survived the compatibility days, so did Jerry. They were very dysfunctional. They were. However, I'm suggesting that we make sure that the council still has some meaningful oversight over the development process, because as it stands right now, we're giving it all to the staff, and I can't accept that.
Okay, and that goes right back to one item that we've already discussed, and that is the city manager that we need to have. If we tell whoever we get to replace Mr. Casella, to my opinion is, if we tell the city manager this is what we want, it's up to him to take care of the staff. The only thing I'm looking at is I don't want us to be micromanaging everything simply because there are laws that are crafted in there that that were made by the state and by the federal government. That's all I'm looking at.
Sure, and I don't disagree. The staff is going to have to be involved, but unfortunately, I think we just handed the whole process over in the past. There's no other explanation, because I cannot fathom how some of this stuff got in there.
Let's go to Mr. Shirley.
Pardon me. Well, as to the staff having the review, the staff has been reviewing everything but Tier 3 projects historically up until March 7th, at which time the tier system was repealed entirely. And at that time, that left staff with all of the review authority over the projects. But the review authority is established in the Land Development Code. That procedural aspect is established in the Land Development Code, which is something that you haven't worked on yet. And so the conforming amendments to the Land Development Code.
As it stands right now, the comp plan doesn't have a section where we can revest some of our authority, and you know very well that a land development code can't conflict with the comp plan. So how would we meaningfully gain any review?
If you're referring to a part of the comp plan that gives staff the authority to conduct all the reviews, are you referring to that? Because I don't see that in there.
Well, under the first tier system, the public benefit analysis was still with the city. As it stands, we don't even have that any longer.
In the Land Development Code, your conforming amendments that implement the new comp plan revisions can create whatever procedures for review that you deem appropriate. So if during that review, you decide that the city council should have some involvement in that process, I'm not sure exactly what form that would take. You're saying it shouldn't be doing the actual quasi-judicial hearings, but some involvement on some level, then that can be built into the conforming amendments, procedural amendments in the Land Development Code. That would not require a comprehensive plan amendment.
And let me jump in a second, because we have initiated an outside resource to go through, because we had the tiering in the Land Development Code. So we've had them start the process eliminating the tiering that would then come back to you as relates to, you know, all of that reviews and so forth. So that, because we've got that inconsistency right now between the existing Land Development Code and the new comp plan that had the tiering eliminated, okay? So that's, and then with the thoughts that you would then want to lay out in your visioning session on May the 3rd, how you want to go about doing what you're talking about doing, because you need to get them synced at some point, and right now they're not synced. But the first administrative step was just eliminating, because you got all through the existing Land Development Code right now, all of that tiering language that is now gone pursuant to the new comp plan. So process-wise, that's how we thought we would work through it. But the comp plan was adopted on March 7th. It was subsequently submitted to the state. I don't know precisely where it is, if the state's. I'm not sure if we received. We should not be. It will go into effect. I need to look at the effective date language in the ordinance itself, but it goes into effect after we get the decision from the state that it's in compliance with state law. We expect that to be forthcoming. And then another 30 days transpires in which a third party can challenge under state law. And if that happens, that goes into the Division of Administrative Hearings and becomes a Chapter 120 challenge. But the reconsideration of the prior plan amendments is a very complicated issue, because if what the council wants to do is just basically backtrack and do exactly the opposite of what was done, then the whole tier system goes into effect and everything else, other things that, if I understand your comments correctly, you would not be in support of either, because the tier system allowed development of a scale which was very much greater than what is in the plan amendments that you've been reviewing. So if I understand your concerns, that would not be an acceptable approach either.
And I don't intend to have the tier system in place much longer. I don't like the tier system, I never have. But at least there were shreds of council authority in it. So I'm going to leave the agenda item on.
Yes.
Compatibility. The problem we had with compatibility some years ago was the fact that it was more of an art than a science. That every time the city took a position on it and we got sued, we lost. The reason why is because in the size of the city of Destin, you don't have much distance between certain types of buildings. You don't have a system which determines what is acceptable and what is unacceptable in terms of a broad plan. So that was the reason that we went from that, is because we were not succeeding in compatibility. We would have experts come in and tell us that it was perfectly compatible. We'd be sued and it wasn't compatible. There are buildings over on the harbor right now in which compatibility studies were run and passed, and suddenly we were found not in compliance. So that was the basis of compatibility. It wasn't a good idea.
So I'm struggling, though, with the ultimate fact. I don't think anybody in here thinks that Destin's done development very well, even in the 30 years that we've existed. I mean, it's been a hodgepodge mess. I I mean, at the end of the day, at least we were still involved in the process, is what I'm saying. Now, it sounds like staff is just gonna make those decisions. Is staff gonna make those decisions? I mean, we can set up the process, but are we gonna really be looking at it?
It's for the council to decide what the review process is. But if either the development applicant or a third party withstanding disagrees with the staff decision, then that ultimately could go to the Board of Adjustment, and that would be basically an appeal of the staff decision regarding the development order. So there is at least there's a due process component that attaches to the review at some point, should a party wish to challenge staff, but it would never be the city council undertaking that. It would always be either the applicant or a third party withstanding.
I'm trying to get where Mr. Destin wants to get, and I heard you articulate you want to have a reconsideration of the comp plan that was recently adopted on March 7th. Schedule that. If the state approves it on Thursday, we open the 30-day period process-wise, then we would then revert back to the old comp plan?
Well, in order to revert back to the old comp plan, an amendment that is exactly the reverse of what has been adopted would have to be prepared, and it would have to go through the local planning agency and two hearings of the city council. So it would have to be adopted pursuant to the very same process that you went through, because it's a comp plan amendment to a current comp plan version. So that's why I said it's not as simple as you might think. In fact, I pity the staff members who have to write the language that reverses the language, the revisions that were just adopted, because it's going to be the inverse of what you're looking at there. So that's going to have to be all figured out if in fact that's the direction that the council goes in.
That's where I'm struggling with from a process side. I understand where Mr. Destin wants to go process-wise. Is it best to do a motion of reconsideration, or is it best to try to get the land development code amended to give you the comfort level that the council wants? Because I don't think it's just going to be as simple as just reconsideration of the comp plan that was adopted on March the 7th.
No, it wouldn't. It would be, all of the same rights, obligations, and rights of third parties and public participants would attach to that amendment process as attached to the process we just went through. So, all the hearings would have to be done, and the parties that are the affected parties would have input and so on and so forth. So.
It's getting late. Here's my issue. There's some language in here that is absolutely terrible in my opinion, especially the language about how we're going to set up the formulas in the high-density residential areas of in the mixed-use areas of the Harbor District. How on earth am I going to get a land development code that actually addresses that, but necessarily conflicts with it?
I don't disagree. You're dealing with process right now. That's what, if you try to unring the bell, that takes time. And then the result is you revert back to the old comp plan. So I guess that's, or do you attempt to amend the new comp plan to deal with? Is that a better process?
Yeah, well, it would be a better process, because then you keep whatever it is that we have already accomplished that you think has merit. You keep that, and you target those areas that are, that the council decides are the areas that are in need of additional work, and then it's a simpler, more straightforward planning effort to undertake that, and keeping it as narrow as possible makes it a much easier process to get through. the broader it is, the more difficult it is to get through because the more issues you have popping up constantly.
Thank you, Mayor. I agree with you, Mr. Destin. I've always said that, you know, we spent $250,000 on this, changing this comp plan, and it's still just shot full of loopholes, and it's just in different areas now. And you talk about, you know, us not having a say-so anymore with the old comp plan, even with the tier system. If you take the building at the foot of the bridge, that apparently is a tier 2, but with the staff making amendments to it, if you put that, if you wanted to build that same footprint, that would be a tier 3. So they started out with a tier 2, but they got around council with amendments and turned it into a tier 3 project. That's my opinion. So, I mean, I agree with you 100%. This thing's full of loopholes, but the council really had no say-so whatsoever what went in it other than just correcting some typos. So I agree with you, 100%. That's all I have, Mayor.
Thank you, Mayor. Oh,
Didn't have my mic on. You have the floor.
thank you. I have voted against this comp plan every step of the way because of issues exactly like what you picked up on. Really, that's all I need to say, but I would be in favor of supporting your motion when you make it, whether it's tonight or in the future.
Again, I don't want to interrupt. Mr. Destin, you need to decide, do you want a motion of reconsideration or you want to amend what we have? I think process-wise, you're better off amending than you are a motion of reconsideration.
Allow me to just leave it on, I'm sorry. Allow me just to leave it as it is for now. I'm going to do some more research, and I don't think I, in foundation, disagree with that necessarily. And like I said, I don't absolutely hate some of this stuff. There is shreds of good language in here. And I think if we could get serious about scrubbing some stuff out, then that's what we need to do, because doing it all from scratch again is not an easy process. You guys have done it. We've spent $250,000. So I don't want us to go through the same process all over again, but the level of it, if we're doing this, the level of involvement from this council is going to have to be more than just telling staff or getting a third party to come tell us what's in it, because there's a lot of stuff in here that is alarming. And I cannot figure out for the life of me how it's going, from a public policy standpoint, benefit the general public. And what I've resoundingly heard from the general public is they want less intensity and less density. And I can't see how in the current language we can create a land development code that does that for them and doesn't conflict with our comp plan as it stands. So I'm just going to leave it on the agenda for now. If I need to withdraw it, I will.
Mr. Foreman? Mr. Dixon?
I don't have a problem with looking at part of it or whatever it needs to be looked at, but, I kind of thought we were going to iron out some of this stuff in the land development code when we go to work on it. And I'm sure that some of these issues can be ironed out when we do the land development code. I just hate to throw everything out and start over. It was a long process. What's happened is we've got new council members on that want to take a look at it and see it in a different light and things like that. And I admire you for it. I don't have a problem with that at all. But I just hate to throw everything out and start over. So when we go through the process of developing our land development code, then to be compatible with it, I think then is when we can come up with some of these and fix some of these issues that you're seeing. So.
Any other discussion?
No, we can move on to whoever has the next report.
Councilmember Morgan.
Thank you, Mayor. I move to nominate Mr. Kevin Schmidt to the Public Works Safety Committee.
Have a motion, have a second?
I'll second that, Mayor.
Motion second, discussion. Those in favor vote yes. Unanimous? Yes.
I just have a few things. First of all, I'm excited about getting Mr. Schmidt involved. I grew up with him here in Destin. He just won Teacher of the Year at Fort Walton Beach High School. He's a local business owner, and it's always nice getting some younger people involved in the city. Secondly, Ms. Lisa Firth kind of answered it for me earlier. I was had a group of private citizens that wanted to purchase the oak trees for Main Street Park. I know y'all are planning one. I don't know the process that you go through to plant more, but we'd certainly like to plant more there if the staff sees fit. So something to consider. And secondly, with Greg, Mr. Casella on his way out, I know one of the big issues this year is going to be the Triumph Gulf Coast money. Mr. Helms mentioned that it may not have to be all used for economic development, which the stipulations were that it had to create a certain amount of jobs. And perhaps we could use it for infrastructure, which would be great. That was news to me tonight. And I would just like the council to consider if they have any ideas on how they would like to go about getting this money. I think it's a huge opportunity for the city. 3 of the 5 board members live or work in Destin. So I think we're in a very advantageous position to secure some of those funds. So if anybody has any ideas, I have a few. I'll put them together for the meeting in 2 weeks. But in the interim, with Greg, with one foot out the door, there is a gentleman that I met. I do think Greg knows him. His name's Larry Sassano. He was the head of the Economic Development Fund in Florida. And so when you lose someone like Greg, you're always going to miss a couple steps. I think we're going to miss several. So maybe have the city reach out to him to advise us, as he's very familiar with the process. And hopefully we won't miss that step, because I think it's a big one for the city. Thank you.
Mr. Miller?
I have no items, Mayor.
I skipped the mayor because he had enough time tonight. City Land Use Attorney, Mr.
I
Shirley?
have nothing else, thank you.
Mr. Casella? Oh, I'm sorry, membership appointment to the Airport Compatibility Advisory Committee. You want to explain that?
Yeah, there is the Airport Compatibility Advisory Committee, which is a combination of Okaloosa County and City of Destin and Eglin representatives. This requires the 3 individuals who represent Destin requires y'all to reconfirm them. So if you could do that pursuant to the recommended motion, that would be appreciated.
Do I have a motion?
Mayor, I'll make that motion. The recommended motion, I move for the appointment of Jan Barr, Patty Stapleton, and Tony Diaz to the Airport Compatibility Advisory Committee.
Do we have a second?
I'll second that.
We have a motion, we have a second. Discussion? All those in favor, vote yes. It's unanimous, yes. First reading of ordinance 1611CN. Which is the approval of perpetual easement. Would you read that by title, sir?
Mayor, I'll read that by title. Ordinance 16-11-CN by title is an ordinance of the City of Destin, Florida, relating to donation and conveyance of a perpetual easement to the Florida Department of Transportation, providing for authority, providing for findings of fact, providing for the need for such conveyance, providing for the mailing of a certified copy of the ordinance, and providing for an effective date. The ordinance is before you for consideration on first reading.
Mr. Casella?
Yeah, this is, we thought we had this is part of the 6 lane of Highway 98 from County Line to Airport Road. We thought we had all of the perpetual easements and temporary easements, license agreements all worked out. Unfortunately, FDOT believed that Airport Road was a county road, not a city road, so we're bringing this back to you as the final step. But this is basically an easement necessarily to do some improvements there at Highway 98 and Airport Road for some loops for the signal as well as some radiuses. So we'd ask for your consideration of this on first reading.
Could I have a motion?
Yeah, Mayor, I'd like to make the recommended motion, please.
Second?
I'm sorry. Somebody already seconded?
I'll second it, Mayor.
Yeah,
I
I
have a
didn't
motion
read
second.
it.
Discussion?
I didn't read it.
Would you please read the motion?
I
into
didn't
the
read
record?
it, okay. I move that the city council approve ordinance 16-11-CN on first reading and direct staff to advertise and schedule the ordinance for second reading at the regular May 2nd council meeting.
I'll still second that.
Okay. Motion, second, discussion? No discussion, I'll call for the vote. It's unanimous yes vote. City manager?
Item 22A is, we were asked earlier this year to identify a law firm that would provide a legal opinion on the development potentials of parcel B and C in Holiday Isle. We've identified Stearns Weaver out of Tallahassee. They have the expertise in land use, real estate, eminent domain, state and federal permitting. And then they also have a staff member that has an extensive planning, background. So what we've provided you is a proposed scope of work for them to do that work. They're evaluating it to be approximately $32,500. They want to break this up into 2 phases. Phase 1, basically, doing all the background research and all that on how the properties were originally converted from conservation to high-density residential, and then subsequently they also would look at all of the core easements. We had Mr. Register come and talk about the spoils easement that was on portions of parcel, portion of parcel B and all of C, but then you had the navigational servitude issues that impacted the southern portion of B. So this accomplishes, I think, what you've asked us to do. One of the things we wanted to point out is that from a conflict standpoint, Stern Weavers ran their conflict checks. The only, and it's more the appearance of a conflict than any direct conflict, is that Stern Weaver does represent an individual who lives in Holiday Isle, who has a ongoing litigation with Legendary Marine. The attorney that would be handling this case and the attorney that handles the Legendary Marine case is not the same attorney. One involves a contract dispute, and this other is ownership. So, but we want to disclose that so that if there's any concerns from the council relating to this assignment. So, as directed, we have provided you this proposed scope, and would ask for your consideration of this.
Mr. Braden?
Thank you, Mayor. I don't know why we need to spend any money for an attorney, because we have 7 different documents that's public record that the city we have here to us is from the Corps of Engineers, starting back in 1993, and the last one is October 3rd of 2014. and they all say the same thing. The government has a perpetual easement on track 101-E6. The government does not plan to release this easement rights, allow any commercial or residential development on this track. This is the track we're talking about. So I don't know, I mean, it's beyond me why we want to spend any money getting somebody's opinion. I mean, our own attorneys have already given us their opinion. This is third and fourth, fifth, sixth, and seventh opinion. Well, there's no way I can support spending a dime on an attorney. Thank you.
And if I was just trying to glance, I've kind of forgotten, I believe it's, the starting number is $30,000 and going up to complete the two different studies they're doing. And if it's the council's opinion that they already have enough information, I'm not too sure either way we'd want to invest that kind of funds in this, but Ms. Ranswell?
Thank you. I'm curious as to why the agreement is dated February and we're just now seeing it?
We originally got the scope in February. It was asked because we anticipated that we would have the election. It was asked to delay this until we had the election, and the current council, since they would be receiving the results, would be able to evaluate this scope and who they were hiring. So that's why it was delayed.
And for some reason, I have in my head that we had said 15,000. Was that?
No, the 15,000 was the not to exceed cost of what, when city hired Joe Boyd to do the Heritage Park evaluation. That was 15,000. We didn't know what this was going to cost, when you authorized us to secure the outside legal firm.
Okay. I agree with Councilman Braden. In fact, we even had the Corps of Engineers come in and give a presentation on this. Why on earth would we want to spend even more money, especially this amount, when we've heard from the Corps, we've got letters, we've got documentation? I mean, I hate to waste the taxpayers' money. The other thing I wanted to bring up is you talked about a potential conflict regarding someone living on Holiday Isle, I guess that's currently represented by Stearns Weaver. I have a concern that Stearns Weaver was actually co-counsel with the attorney of record for Parcel B, Matthews and Jones law firm, last year in a Sandestin lawsuit.
That was not disclosed. You have that factual?
Yeah, I have it right here. Sandestin Investments, LLC versus Walton County, a political subdivision of the state of Florida and Walton County Board of Commissioners. The attorneys of record, Darren J. Quam, Ronald L. Weaver, and Aaron Okuno of Stearns, Weaver, Miller, Weisler, Alhadeff, and Sitterson, and Dana C. Matthews of Matthews and Jones, and this was just disposed of last year.
We gave them the list of everybody we could think of that may have a potential involvement in Parcel B and C, and they did not pick up a conflict. That's why we provided the list, and so I can't tell you if there was a conflict or not. They didn't disclose that. They did disclose the other.
Personally, I think that's a conflict, but I'll leave that up to council.
Okay, Mr. Dixon?
Yes, whenever this was being discussed and we actually voted to do this, I hadn't seen everything that the Corps' presentation and everything that I've read, but I have to agree now that in my opinion, that property is not buildable and there's no reason to spend the money on this attorney. So.
Thank you. Any other discussion? Do we need a motion? We need to rescind I guess the council just authorized them to do the research.
You'd only need a motion if you're going to engage them.
Okay.
So just
Do
for
we need
the
a-
record, if you
do we
want to
need-
ask for one, and if there isn't, we'll have that of record.
Do we need, or is there a motion to have this, ask this, or request the staff rezone this to conservation or some form of designation that would indicate it is not buildable?
That's what I do.
Like I've been told to shut up.
Mr. Mayor, may I comment on that? Because the fear that we've had the whole time is downzoning. The fact is, you go in and you arbitrarily change the ability of a property owner to get out of that property what they can get under a current zoning category. And so the conservation is a federal designation, not necessarily a state or municipal designation. And so by going in and changing it to conservation, we're picking up something that is really not part of our code and has implications to it that you're going to restrict that area to only the conservation category that the federals use. So am I making sense on that?
You're making sense. Mr. Miller just tried to explain it to me, but.
Well, no,
but
I
it-
tried to explain it at that meeting where the engineers were here, but the mayor cut me off and told me she knew where I was going, didn't want me to say it, so I shut up. And the fact is that it's very clear to me, you gotta be, from a municipal standpoint, very careful about downzoning. Because when you do that retroactively, you've taken somebody's property.
We're not talking about that.
That's what you're talking about in conservation. Oh, absolutely.
I mean, it was basically.
This is
zoned
not to hire the
single family
attorney.
Huh?
This is not to hire the attorney to do the research. This is,
Well, that's, what I was saying is I agree with you now that we didn't need the attorney.
I'm saying the same
Okay?
thing.
And I said for that reason, because the fact is, de facto, it's restricted from any building over there, so long as the engineers have spoils areas. And so why would we go in and create something that might involve us in a rather heavy lawsuit? Just for that practical reason. It's kind of like prayers. You know, we don't need to do it because nobody's forced us to. But anyway,
I believe my,
Ms. Reynolds, you got the floor.
I believe my suggestion when we first talked about this was making it conservation private or something as opposed to conservation federal, because obviously it's not federal anymore. But a way to distinguish it as being privately owned as opposed to state-owned.
it's not what we're talking about.
I have a rhetorical question. We never made a motion. Why are we even discussing it
That's
still?
exactly.
Is that a point of order?
I'll make it a point of order if I have to, Mayor.
Do we have a motion of any kind? Ms. Ramsel? Or is that? okay,
No,
sorry.
I didn't have anything, but if we need to make a motion to reject the motion, I'll do that.
No, we don't. No, we just have to, we've been told we just have to not vote. Mr. Casella, you want to continue?
Yeah, 22B is we've got a request by Mr. Buckingham with, in Buck Smokehouse on May the 20th, I believe is the date, to use the southern portion of the Marlar parking lot for a special event, basically for first responders, charities. This would be both the Sheriff's Office and the Destin Fire Control. I don't have the authority, and it's not vested in the city managers to use or permit those activities in the Marlar parking lot. I don't have a problem with it. I just want authorization to do that. If that's agreeable to council, we'd bring that back to you on the May 2nd agenda. There is an issue of, I think they want to use and dispense alcohol. It's been represented to me that they'll be able to get the appropriate license permits from the state beverage folks to accomplish that, and they'll provide to us naming us an additional insured, the appropriate insurance. So again, I'm authorized by permit to allow alcohol at Morgan Sports Center as well as the Clement Taylor and the community center, but not the Marlar parking lot. So I'd ask for your concurrence with this, and we would bring this back to you in an agreement form on May 2nd.
Do we need a motion?
Yes.
I'll make the motion that we approve it.
We have a motion, we have a second. Discussion? No discussion? Call for the vote. It's an unanimous yes vote. Mr. Caselli, you want to continue?
Yeah, on 22C it was requested at the last meeting by Council Member Ramswell to bring this back to you on the agenda. This was initiated during the visioning session in 2015, was to explore the pay to park in the appropriate areas of the city. We discussed it again on March 16th with the City Council to give us direction. And we looked at it comprehensively from Crystal Beach to Restaurant Row all the way down to the harbor. And I believe at that point it was to use as a pilot program the Marlar Street parking lot for the 2016 season and to try to do a demonstration there. So what you have before you is to try to keep the expense of this trial program to a reasonable cost, is that there's lots of different ways to meter parking. You can pay and display, the pay by space, pay by license. There is new technology relating to, it was app-driven from smartphones that is relatively inexpensive compared to the other hard infrastructure. So what this is, and they charge about $250 a month, and then 25-cent convenient fee for every user. So what we're bringing this back to you and is to get some policy direction. Is this something you still want to do? You got 140 parking spaces in the Marlar lot. We could have it ready, by June 1 of this, and carry it through at least through the end of October. If you, this is what you want to do. We're suggesting if you do it, a rate of $1 an hour. How many hours do you want to operate it? As you know, the Marlar lot is potentially used all the way to 4 or 5 o'clock in the morning, and then, what time in the morning do you want to, reactivate the parking? So we're asking for some policy direction. Again, if this is something you're committed to do, so that we could get it done by the 100 days of summer and into September and October. Steve, did I miss anything?
I think you pretty much covered it all.
Okay. I'm sorry, I didn't cancel the vote. What can I?
Okay, the paid parking was probably something that I suggested some time back based upon the shortage of parking spaces down in the, for example, down Seibert. There's very wide right-of-ways there, and we're talking about mostly special events. We're talking about overflow type times when you're going to need the parking, when the businesses can't accommodate it, and where we can, contrary to what we may have said in the comp plan, I've never believed in a parking garage as such, but I do believe that we have to organize our parking in the city to the degree that if we are able to meter and to collect some funds, that we can build a reserve, perhaps we can buy property and provide additional overflow parking. It'll be a paid for type operation, and hence the pilot program. It may not work, but from the cost estimates so far, it looks like, at least investigating it, going ahead and trying it, particularly on our own property, that we may come up with something. And this could be expanded out to other areas such as Crystal Beach and areas. And so that's the idea behind it. I've visited some other parts of the world where these old cities are packed, and they have to have, you know, this kind of parking, and they have some very innovative ideas to do it. So that's the idea behind it, and I'll make the motion. I'll make the motion to proceed with the study of it and to give us a proposal.
This is the proposal, so if you want to implement it by June 1st, so.
Then I make a motion that we pass this proposal. I don't have it in front of me, so.
There's several options in the proposal here we could select.
We would recommend, at this point, if you want to do it, an hourly rate of $1 an hour, and it would use the passport, which is relatively modest cost. And then we would start at June 1 and continue to November 1. And then our hours of operation would be from 11 a.m. to midnight. So that's what you want us to do.
That's the system that will require you to have a smartphone.
Yes.
If you don't have a smartphone, you won't park the place.
Yeah.
Whoops, sorry. Did you all hear that? Okay. Mr. Marler?
Thank you, Mayor. A weekend ago, I had the pleasure of going to Baton Rouge. Well, we haven't got it. Who we second? I'm sorry.
Yeah, you.
Well, but besides
But second the motion first.
I'll second the motion for the discussion, okay. Besides the
Marler.
fact that I listened to some wonderful blues bands during one of their festivals they have on their Riverwalk, the interesting thing I did see was the paid parking areas. They had one section, it was basically almost like an ATM, except you put your card in, and it told you how many, and you punched in how many hours you wanted. And what they had was each parking space had a number. You took your number, and then you got a piece of paper, you put it on your windshield for the duration. The only heartburn I have with this is we have enough problems trying to get people to park in the MARTA parking lot now. I don't know if putting a meter is going to be the right idea, simply because that's going to turn them the opposite direction. I think it's a great idea if we can get it to work, and a great way to get a revenue source to build a parking garage sometime down the road. But I just wonder if we're really going to bite the hand that feeds us on that, since we're just trying to get people to go to that parking lot right now. That's all.
Mr. Foreman? Well, I'm sorry, your microphone's off, but you don't have the floor. I apologize. I didn't turn you off from your last one. I'll give it to you in a minute. Mr. Dixon?
I think this is probably one of the most ridiculous things, and I've heard ridiculous up here a lot tonight. So I got to tell you, that parking lot is not utilized. It may be 5% of the time it's utilized, and I go through there July sometimes, and there's 10 cars in there, and I just can't for the life of me see how putting meters or where we're going to start charging for that is going to enhance that use of that. I do understand that we are putting in some crosswalks there that may make it to where people use it a little bit more, but another thing that I see is some of the churches in that area, and we've been all about churches tonight, are using it for their overflow parking for the church services. And so are we going to charge people to come park in there on Sunday for that hour or hour and a half that they're there to park in this parking lot? I just think that if we were going to put in a multi-story parking garage or something like that, certainly we need to repay that somehow, but this is paid for. The citizens already paid for this, and for us to go in there and basically put parking in this, or charge for parking in this area, I feel like it's just basically trying to collect every nickel we can for everything that we can here in this town. I just can't agree with it. It just doesn't make sense to me to put metered parking in a place that is underutilized as it can be, to make it more underutilized. Thank you.
Mr. Braden?
Thank you, Mayor. Yeah, I too couldn't support it. I mean, I've had a lot of citizens voice their opinion on this and said the same thing. It's crazy. You know, nobody's using it now. I think that's, out of all the parking lots we have, it's the only one that's not being used. So yeah, I can't support it. Thank you, Mayor.
Ms. Ramswell?
Thank you, Mayor. My original thought when we discussed this was doing it along Crystal Beach, down Old 98, in that area, where people are parking on the sides of the streets, they're parking in the right-of-way. At least utilize it there. Again, I agree with Councilman Dixon that the Marlar parking lot's already been paid for with taxpayer dollars and is underutilized. That's going to be a waste of a test and not really in the area that I had actually been hoping, and what I'd heard from folks out there were hoping might be a more suitable and efficient way of gauging whether something like this might work over a larger area. So I would not support it at the Marlar parking lot, but I would support it in the areas of Old 98 along Crystal Beach.
Any further discussion?
That particular issue, y'all discussed that on, we gave you that comprehensively, and that's when y'all voted to do the Marlar. That's why this plan is being presented. This was pursuant to y'all's direction, so.
No further discussion. I call for the vote. A yes would be to implement the plan, and no would be to discard it. Mr. Destin? Nope. Overwhelming. 6 noes, 1 yes. It fails. I would accept a motion to adjourn.
Wait a minute, let me, whoa. Yeah, let me.
Oh, that's right, I'm sorry. I thought-
We got some other issues. I just want to give you some updates on. You were given a little flyer for some things at the library. One was the General Seibert on the 21st at 2 p.m. and then the week after that, we've got the free jazz on Friday. Well, it was Friday, April 22nd at 2 p.m. Just a reminder, you got your visioning session on May the 3rd. There is a cleanup if the weather doesn't turn for Noriga Point. Cleanup on at 8 o'clock to 10 o'clock on Friday out there on the site itself. So just give you that recommendation. And just as a housekeeping measure, at your last meeting, y'all had made a motion, supported 6-0, to have the city's land use attorney and myself present to the Trust for Public Lands the concept the BI had suggested. I would respectfully request that I be excused from that assignment, especially since I'm in the transitionary stage, and that I've got some ethical issues with that, as well as I believe what is being suggested infringes on the fishing fleet's riparian, and I don't think I'd do the city justice. So I'd ask to be excused from that assignment, and that y'all appoint somebody else to work with the city's land use attorney on that particular matter.
I'll make the motion excuse if we need a motion.
Second.
Motion, second. Discussion.
I need to probably abstain, so I'll declare that my father's shareholder BI.
No further discussion. Call for the vote. Six yes, 1 abstain, motion passes. I assume we need to follow up with a discussion or another motion as to who will attend with the city attorney, or the land use attorney. Pleasure of the council.